Imagine this. A wealthy investor from Dubai stands on the balcony of her Miami Beach hotel, gazing at the skyline. She has $30 million to invest and is deciding between your Florida business and a competitor in Delaware. The difference? Your competitor has structured their holding company to maximize tax efficiency, minimize liability exposure, and provide the governance clarity that international investors crave. Meanwhile, your company's structure leaves her legal team with unanswered questions and concerns about future regulatory hurdles. In that moment, which investment do you think she'll choose? I'm Santiago Cueto, a board-certified international business law expert and best-selling author. I've helped Fortune 100 companies and ambitious entrepreneurs protect their business, win lawsuits, and navigate the legal side of success. Let's get into it. In today's global capital landscape, the architecture of your Florida holding company isn't just a legal formality. It's your most powerful tool for attracting the $120 billion in foreign direct investment that enters our shores annually. Today, I'll show you exactly how to build that magnet. Florida has emerged as a premier destination for foreign investment, offering a unique combination of geographic advantages, favorable business climate, and lifestyle appeal. But to fully capitalize on this opportunity, your holding company structure must address the specific concerns and objectives of international investors. First, let's discuss entity selection. While Delaware C corporations are often default choices, Florida offers compelling alternatives. The Florida LLC provides remarkable flexibility in governance while maintaining limited liability protection. For foreign investors, especially those from civil law countries like Brazil, Spain, or Italy, the familiar corporate structure of a Florida C corporation often provides greater comfort. However, the real power comes from combining entities in a tiered structure. Consider creating a Florida C corporation as your primary holding entity with subsidiary LLCs for operational assets. This structure allows foreign investors to enter at the C corporation level, providing them with familiar corporate governance, board representation, and share certificates, while maintaining the asset protection benefits of segregating operations in separate LLCs. This approach particularly appeals to investors from Latin America and Europe, who often seek both governance transparency and asset protection. Second, tax efficiency is paramount for international investors. Florida's absence of state income tax creates an immediate advantage, but the structure must also address federal tax considerations. For foreign investors, concerns about the Foreign Investment in Real Property Act, or FIRPTA, and branch profits tax can be significant barriers. Structure your Florida holding company to include a blocker corporation that shields foreign investors from direct exposure to U.S. taxation on operational income. This approach transforms potentially troublesome, effectively connected income into dividend payments, which often receive preferential tax treatment under applicable treaties. For investors from treaty countries like the United Kingdom, the Netherlands, or Germany, this distinction can reduce withholding tax rates from 30% to as low as 5 to 15%. Third, governance provisions must balance control with protection. Foreign investors typically demand strong minority protections before committing capital. Your operating agreement or bylaws should include supermajority voting requirements for major decisions, tag-along rights, anti-dilution provisions, and information rights. Consider implementing a dual-class structure that allows foreign investors to maintain significant economic rights while addressing any concerns about foreign control or sensitive operations. And fourth, dispute resolution mechanisms tailored to international investors are essential. Florida's court system may be unfamiliar territory for foreign investors, so structure your governing documents to include arbitration clauses that specify neutral forums like the International Chamber of Commerce or the American Arbitration Association. This provision alone can overcome significant hesitation from investors in jurisdictions where court processes differ dramatically from the U.S. system. Finally, exit mechanisms must be crystal clear. Foreign investors typically have shorter investment horizons than domestic counterparts, often 3 to 5 years versus 7 to 10 years. Build in staged liquidity options, including redemption rights, put options, and clearly defined valuation methodologies for investor exits. These provisions create the certainty that international capital demands. The global competition for investment capital is fierce. When you structure your Florida holding company with these 5 elements: strategic entity selection, tax efficiency, balanced governance, international dispute resolution, and clear exit pathways, you transform your business from merely another investment opportunity into a sophisticated vehicle precisely calibrated for international capital. Remember that beyond the technical structure, foreign investors seek partners who understand their unique perspectives and needs. The most successful Florida businesses don't just create legal structures, they build bridges to global capital markets. By implementing these strategies, you'll position your Florida holding company not just to attract foreign investment, but to become the preferred destination for it. The future of Florida business is global, and with the right structure, your company will lead the way. Winning in business means staying one step ahead. Subscribe and like for more winning strategies, and drop a comment if there's a topic you want me to cover next. See you in the next one.